This Honorable Court of Appeals of Tennessee is in session.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate each of you agreeing to participate in this oral argument via Zoom today. We believe it's the best way to continue to conduct the court's business in this interesting time we're living. Want to run over just a couple of matters before we get started. First, I want to introduce your panel for this morning. We have Judge John McClarty from Chattanooga, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Even though we are conducting this oral argument via Zoom, the same rules and protocol will be in force as if we were all standing in the courtroom together today. Which means each side gets 15 minutes to make its oral argument, and if the appellant has reserved rebuttal time, he will receive that rebuttal time. Anything we need to take up before we get started, Miss Angie?
No, Your Honor.
All right. Mr. Thigpen, are you there? I understand you're just using audio. Is that correct?
That is correct.
Okay. All right. In just a moment, I'm going to allow you to begin your oral argument. It's my understanding you've reserved 5 minutes of rebuttal time. Is that correct?
That is correct.
Okay. And once we start, you'll have 10 minutes to make your oral argument. And then once you finish, the appellee will give its oral argument, and then you'll have your 5 minutes of rebuttal time. Any questions before we get started, Mr. Thigpen?
I thought there was a 5-panel convened.
No, sir, it's a 3-panel.
I wonder why the court clerk would send me information stating that.
I have no idea, Mr. Thigpen. Are you ready to begin your oral argument?
Sure.
All right, you may proceed.
Well, as I stated in my appellate brief, the trial court had abused his discretion in all farcical show trials that he presided over in Trousdale County Chancery and in Circuit Court, which is subsequently he presided over those two issues in Chancery and Circuit at the same time, while neither had been heard or decided, and clearly had no jurisdiction or authority to act. His assignment by then Chief Justice Bevins was improper. That's not in my appellate brief, but it is facts and it's public record in the appellate court, which the court clerk has deemed not worthy of publishing to the public record, like many records in this instant appeal. Appellee Burnley's argument before Acre was absolutely ridiculous, and his decision and holding in dismissing defendants Burnley's was absurd, saying that any person without a witness could actually have another person arrested for simple assault. And that actual issue was waived long before Judge Acre agreed it was not. And the name of this case was never properly assigned the estate of Kent Howard Smith. Not ever. That requires the judge to do that. And the trial court was too busy having a heart attack and trying to find his mind, as best I could tell. He didn't even do the final dismissal. He had a standing recusal order that was never heard. And then it was only entered into the court, into the trial record, long after he had lost jurisdiction and authority. And I don't believe for a minute that he dismissed it. He signed that order on December 12th. I think he realized after the fact when the clerk and master brought it to his attention, they needed to do some reverse engineering. And further, the trial court, while in the Trousdale County Circuit Court, where his reassignment was highly irregular and improper, inserted himself absolutely wanting authority and jurisdiction in 2016 CR 062, which is a criminal case not associated with either of the cases that he is under appeal with, colluding and being complicit with the state of Tennessee and these two appellees. It's absolutely absurd, and for clerk and master Bronner to waive all requirements for the administrator to Kent Smith's estate, who is not Kent Smith estate, is not who this appeal is against. It's against Kent Smith et al. And et al. Would be defendants Burnley's, and none of it comports with the rules. And it appears to me to be a foregone, predetermined conclusion starting back in general sessions in Trousdale County in 2014. It only took almost a year and a half for a incontrovertible and indisputable writ of quorum nobis to overturn that conviction, because it was so outrageous. Over 20 counts of aggravated perjury. And now we all want to pretend like, oh, that's fine. Sure. Any person should be able to have another person arrested for assault by saying, I saw him. He was afraid because he said so. And even though it required a witness, that would be defendants Burnley's, Judge Acree to accept the argument from Counselor Powell, that never happened. That's not the way it works, when he knows good and well it was, and he was there, I was there, and so were others. There's not really much left to say. They've already emptied and divided up all assets from Mr. Smith's estate, who incidentally died in state custody for soliciting my first-degree murder. No big deal. He's a cousin to the lived too long District Attorney General Tom Price Thompson Jr. And, this is all a farcical proceeding, all of it. And with no disrespect to the court or you judges, it is just absolutely ridiculous. And Acree's conduct is far outrageous. He should actually be removed from the state's judiciary. That's pretty much all I had to say right now. I'll wait and hear what the appellees have to say.
All right, we will hear from the appellees then. I don't know who's going to start the argument, but it's my understanding that you are sharing the time equally.
That's correct.
All right.
I'll defer to Mr. Powell. He can begin. I think mine's will be pretty short, Your Honor.
Okay.
All right. May it please the court. We're here today on Mr. Thigpen's appeal as it relates to the appellees.
Well, you need to introduce yourself since this is
I'm sorry. I'm Jeffrey Powell. I represent the appellees Dion Deshay Burnley and Marie Deandra Burnley. And we're here today on appeal, Mr. Thigpen's appeal from the trial court's granting of the Burnley's motion to dismiss. Let me just go over the relevant facts, and they're brief in this case. So Dion Burnley and Kent Smith had shops that were next door to one another. Dion Burnley, at the time this happened on September 29th, 2014, didn't know Mr. Thigpen and really didn't know Mr. Smith either. Mr. Burnley was in his shop. He heard a commotion, two people arguing. He went outside to see what was going on. He saw Mr. Smith and Mr. Thigpen arguing. He heard Mr. Thigpen threaten Mr. Smith. When Mr. Thigpen saw Mr. Burnley, he left. And Mr. Smith, who was an elderly gentleman, told Mr. Burnley he threatened me. And Mr. Burnley's comment and reaction to him was, well, call the police. Well, he said, actually said, call the cops. Call the cops. Sometime later, maybe an hour later, Mr. Burnley, who had left his shop, got a phone call from an Officer Cato, I believe. And Officer Cato asked Mr. Burnley if he would come down to the station to give a statement. And Mr. Burnley said, no, I don't want to get involved. I don't want to come down to the station. And so Mr. Cato said, well, Officer Cato said, well, can you just tell me what happened, what you heard and saw? And that's exactly what Mr. Burnley did. He told the officer what he heard and saw. So apparently after that, Mr. Thigpen was arrested. Sometime shortly after that, because it didn't take long for the trial, Mr. Burnley received a subpoena to testify at trial. So he went to trial and he testified to what he heard and saw. And Mr. Thigpen was convicted of assault. Then I'm not completely sure about all the details of why it was set aside, but at some point it was set aside and Mr. Thigpen then filed this action. And as it relates to the Burnleys, he filed this action for 3 causes of action: malicious prosecution, intentional infliction of emotional distress, and civil conspiracy. And I'll take those in order. So Mr. Thigpen's malicious prosecution claim should fail for 2 reasons. As the court knows, there are 3 prongs to proving malicious prosecution. One is that the underlying action was instituted without probable cause. 2, that the defendant brought that action with malice. And 3, that the prior action was terminated in plaintiff's favor. I think Mr. Thigpen can prove the 3rd one. It was terminated in his favor somehow, but he can't prove the first 2 prongs. Number 1, it was instituted with probable cause. Apparently, Mr. Smith, after this incident, went to the police department, told the police that Mr. Thigpen threatened him. And they didn't immediately go and arrest Mr. Thigpen. They called Mr. Burnley on the phone and corroborated that. And that corroboration, along with Mr. Smith's telling them that Mr. Thigpen threatened him, was enough probable cause. As we know, probable cause and beyond a reasonable doubt are 2 different standards. But Mr. Thigpen was subsequently convicted at a bench trial beyond a reasonable doubt. So I submit to the court that there certainly was probable cause there for his arrest. The stronger of the 2 arguments, though, is that that the defendant brought this action with malice. Mr. Burnley, and certainly Mrs. Burnley, had nothing to do with this at all. Mr. Burnley did not institute this action. Mr. Smith instituted this action. So because Mr. Thigpen can't satisfy the first 2 prongs, we submit to the court that the malicious prosecution claim should fail. His second claim is intentional infliction of emotional distress. This is a personal injury tort that is governed by TCA 28-3104. It should have been brought within a year. This cause of action would have accrued on September 29, 2014. And Mr. Thigpen did not bring this action until almost 3 years later. So we submit that this claim is time barred. And the same would go for the civil conspiracy claim. It is a 1-year statute of limitations on that. Again, Mr. Thigpen filed this 3 years after this alleged civil conspiracy would have approved. So we submit to the court that this should have, that this cause of action is time barred as well. And let me just say one other thing about Marie Burnley. Mr. Thigpen brings her in on the civil conspiracy claim, claiming that she allowed Mr. Burnley to use her cell phone to call the police. Number one, Mr. Burnley did not call the police, they called him. Number two, they called him on his phone. So she had absolutely nothing to do with this whatsoever. But in any event, that cause of action is time barred. So we submit to the court that that because all of Mr. Thigpen's causes of actions fail, that this court should affirm the decision of the trial court as it relates to the appellees Burnleys.
All right, sir. Thank you very much. We will hear from the other appellee now.
Good morning. I'm Tracy Parks. I am a member of the Wilson County Bar. I represent the estate of Kent Howard Smith and the administrator, Crystal Smith Coughlin. Unlike Mr. Powell, was not really involved in this matter at the trial level. I did not know the decedent, Kent Howard Smith. So the issue here as relates to my clients are whether or not Mr. Thigpen, the appellant, properly sought to substitute these parties in pursuant to Rule 2501 in a timely fashion. He did not do so. The trial court recognized that he did not do so in a timely fashion, and the trial court properly dismissed all causes of action against Kent Howard Smith or the estate with prejudice by its order of January the 19th of 2021, and I believe would reaffirm that dismissal in its March 8, 2021 order, which denied a subsequent or late motion to substitute filed by Mr. Thigpen. The record reflects in this matter that Mr. Smith, who was named initially as a defendant by Mr. Thigpen in the underlying action for tort, died on March the 20th of 2020. His daughter, Crystal Smith Coughlin, was appointed administrator on May the 11th of 2020. And notably, in the court file on June the 1st of 2020, in a response to a motion for a judgment on the pleadings filed by on behalf of the Burnleys by Mr. Powell, Mr. Thigpen, the appellant, noted in his response that he was aware on June 22nd, he included Crystal Smith Coughlin as a party, though at that point no substitution, no motion for substitution had been filed. And in fact, at that point, no suggestion of death had even been filed on the record. So Mr. Thigpen was aware of Mr. Smith's death even prior to it officially being noted in this record. Mr. Thigpen, I note, has apparently accused the trial court of never properly assigning the estate of Kent Howard Smith to this matter, which is trial court's number 7663. But in fact, it was not the trial court's duty to do so. It's Mr. Thigpen's duty to bring in a party, substitute party, to revive his claim if it's revivable. So on June the 29th of 2020, the court recognized on the record that Mr. Kent Howard Smith had deceased and noted in its suggestion of death that if Mr. Thigpen chose to proceed on in substitution, he should do so pursuant to 2501. That triggered a 90-day window in which Mr. Thigpen had to substitute in not Ms. Crystal Smith Coughlin, as he seems to have indicated he needed to do, but her in her representative capacity as administrator of the estate. He never did so. And some, I think 100 and over 90 days later, we filed a motion to dismiss. The court dismissed the action. During that 90-day window, Mr. Thigpen never filed anything with the court, never sought to expand the time or ask for additional time pursuant to Rule 602, which could be available to him during that 90-day window. Subsequent to the 90-day window closing on him, he never came into court and said, "Hey, please find that I have some excusable neglect here for not substituting this party." In fact, he's never argued that in his brief. He's not argued it today to the court. There's no record. In fact, the court, in its order of dismissal on January the 19th of 2021, found that there was no excusable neglect. And I would submit that is the only mechanism by which the trial court, or even this court, I think, could approve a substitution party beyond the 90-day window. That didn't occur. There's nothing in the record that would indicate that it exists. In fact, I pointed out in our brief, Mr. Thigpen has not been compliant with the rules of this court in even referencing the record throughout his brief. I think the court could just dismiss any of his arguments for consideration, because he's not properly supporting those by reference to facts that are within the purview of this matter. And we did not cite in our brief, but we rely on the case of Dobbins v. Green, which is a 2013 case, the Court of Appeals case.
What you need to do, Mr. Parks, if you've not cited that case, you need to provide it as supplemental authority to the court, and also send a copy to Mr. Thigpen as well.
I will be glad to do that because that particular case does say that this should be on the merits, dismissed with prejudice when this 90-day window is missed. And I'll be happy to supplement that so that we have it in the record. But that is our position, that he failed to act. There's no one to blame but the appellant for failure to act. We ask the court to affirm the dismissal with prejudice as to both the estate of Kent Howard Smith and Crystal Smith Coughlin, who, by the way, Mr. Thigpen says on page 3 of his brief, is not a party to this instant appeal. Thank you.
All right, thank you. Mr. Thigpen, you have 5 minutes in rebuttal, sir.
Addressing Mr. Parks, Kent Smith did not die on March the 20th. He died on March 27th as being a victim of his attempt to solicit my first-degree murder, and him getting a soft slap on the wrist for a mere 6 years in jail at 30% and blew parole 3 times. He died in DuBarry, not in Hardeman County. He died in the wacky place, and they weren't going to let him out because he was trying to put hits on Sheriff of Trousdale County, Tommy Thompson, and a few others, including the confidential informant. As far as my not communicating or attempting to file anything in the court about recognizing a substitute defendant, that is patently false. Whether or not the clerk and master, who absolutely should have resulted in a venue change when CK recused himself from this, left that in the record, or whether or not the trial court or his assistant accepted the fact they knew I had been kidnapped and falsely imprisoned. So did the appellate court, several of them, by a Judge Brody Kane, and sent to a very harsh maximum security Robertson County detention center, while all the judicial districts were supposed to have submitted plans to reduce jail populations by suspending sentence for nonviolent misdemeanors, which, even if the Trousdale County jury trial wasn't a kangaroo court and a farcical show trial, that would have been me. And no, I did communicate that was communicated to them. Now, as far as Powell is concerned, Dion Burnley had his shop not even 200 feet from my back door where I lived for 22 years. He knew me. He did business with me. That is absolutely false. The trial court in that matter, Kenny Linville, that has gratefully retired, even though he placed her with his niece. He knew me. He knew Kent Smith. He knew Dion Burnley. Dion Burnley lived in a house that he bought from Kenny Linville. And, and it's a house that Kenny Linville bought off the courthouse steps. And he presided over that. It was farcical. It was ridiculous. It was not a due conviction. It was just an insult to anything resembling justice. And for Mr. Powell to advance the argument that Dion had nothing to do. Dion's testimony, it's been published on the net, the trial and Kent Smith's statement. There were over 20 counts of aggravated perjury between Kent Smith and Dion Burnley, and they were working with, both of them had very close familiar family ties in the district attorney general's department, and it was a complete farce, and it was overturned, and it took a year and a half because Kenny Linville would not hear it. And the trial court clerk, Kim Taylor, who is being sued right now, and I think she got dismissed because Mitchell messed up in the United States District. But she'll be sued again for flagrant violations of honest services in the other case that's currently under appeal, unless the court clerk, the appellate court clerk, decides I can't appeal that matter, which he seems to be predetermined that he's going to do. So no, his argument that anybody can go have anybody arrested for simple assault, that Dion Burnley was there. He was not there. That was not his phone. That was his wife's phone. And Dion testified that he spoke to the police immediately, not an hour later. And it wasn't an hour later. It was 42 minutes later. Kent Smith walks in, says, "Oh, I went to McDonald's and had coffee," which wasn't where he went. He went to the sheriff's department and talked to the magistrate, blah, 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 and then went to McDonald's and then went down to the police. But they both testified they went immediately. Dion Burnley was not there. So most ridiculous.
Mr. Thigpen, you've used your rebuttal time.
Yeah, great.
All right, we will take this matter under advisement. We will render an opinion, a written opinion, as soon as possible in this matter. We will serve a copy on all parties. Again, I appreciate your participation in this oral argument via Zoom. Ms. Angie, if nothing further, we'll recess court until the call of the next case.
This
If I
honorable court is in recess until 12:30 p.m.